Welcome to the Growth Mindset Company channel, where we explore fascinating topics that expand your horizons. For an even deeper dive into today's topic, head over to www.wisdomwaveshub.com. You can find the link in the description below. Now, let's get started. Today, we're delving into the world of arbitration. But what exactly is it? Arbitration is a binding approach to resolving international disputes. It's like a faster and more cost-effective alternative to courtroom litigation. The word arbitration has its roots in Latin, arbitratus, meaning judgment, derived from arbiter, which refers to an individual who offers an opinion or judgment.
Now, let's talk about historical backdrop and its progression. Arbitration isn't a new concept. It goes way back in history. Ancient Greece, for instance, used arbitration to settle maritime trade disagreements. Throughout the ages, arbitration evolved, adapting to changes in international commerce, legal intricacies, and technological advancements. This journey led to the creation of international conventions and entities like UNCITRAL and the ICC, aimed at streamlining and facilitating arbitration on a global scale.
Now, let's talk about the legal foundations of arbitration. There are various legal structures, including national laws, global treaties, and specific rules agreed upon by disputing parties. The 1958 New York Convention is a game changer, promoting the recognition and enforcement of international arbitral awards. Additionally, many countries have their own statutes for arbitration within their borders. Arbitration relies on key legal tools to function smoothly. Here are some of them. The 1958 New York Convention, a crucial international treaty that ensures the acknowledgement and enforcement of international arbitral awards. UNCITRAL Model Law. This provides a foundational framework for arbitral proceedings, adopted by numerous global jurisdictions. National Arbitration Acts. Individual countries have established rules to guide arbitrations within their territories.
Within a broader contract, you'll often find the arbitration agreement. It's a pivotal component that represents the parties' consensus to use arbitration for dispute resolution. Here are its critical components. Defining boundaries, outlining which disputes fall under arbitration. Legal governance, specifying the legal norms or jurisdiction overseeing the arbitration. Arbitral panel, explaining how arbitrators will be selected. Procedural directives, choosing institutional norms, like ICC or UNCITRAL, or agreeing on a custom procedure. Location and language, determining the arbitration's venue and official language.
Arbitration, though structured, offers parties a platform to present their case before an impartial adjudicator. Let's walk through the key stages. Launch. It all begins with the claimant, who initiates the process by detailing the dispute and often suggesting a potential arbitrator. Reactions and counter-responses. The respondent then steps in, outlining their stance, introducing counter-arguments, and even proposing their own arbitrator. Forming the arbitral board. Typically, this board consists of 1 or 3 arbitrators, chosen in a manner agreed upon by the parties. Preliminary discussions. Initial meetings address procedural aspects, including submission timelines and hearing dates, setting the stage for the process. Written submissions. Parties present their standpoints, providing evidence, and sometimes incorporating witness testimonies or expert analyses. In-person sessions. Depending on the case's complexity, parties may choose to present their arguments directly, including cross-examining witnesses and experts. Post-session summaries. After in-person sessions, there's room for additional written arguments, ensuring all perspectives are considered. Decision. Finally, the arbitrators convene and reach a conclusive decision or award, which typically binds the involved parties.
Now, let's explore the merits and demerits of arbitration. Expertise. Arbitrators often bring specialized knowledge relevant to the dispute. ensuring a deeper understanding of the issues. Privacy. Arbitration's confidential nature is a stark contrast to public court trials, preserving the confidentiality of sensitive information. Global recognition. Thanks to international conventions like the New York Convention, arbitral decisions have global enforceability, providing security for international businesses. Cons. Potential high costs. While arbitration is generally viewed as cost-effective, complex cases can escalate expenses, making it less attractive in some situations. Limited appeal options. The binding nature of arbitration means there's limited room for contesting the outcome, which can be a drawback if parties are dissatisfied. Multi-party complexity. In cases involving multiple entities, coordinating arbitration can become intricate, adding complexity to the process.
Now let's embark on a detailed exploration of ICC arbitration, renowned globally as the international benchmark for resolving complex international disputes. ICC arbitration is an esteemed arbitration service provided by the International Chamber of Commerce, ICC, headquartered in Paris. This organization is not only known for its neutrality and expertise, but also for its extensive history in facilitating international business transactions. ICC arbitration is a top choice for handling intricate international disputes due to its commitment to fair, impartial, and efficient proceedings. Now, let's dissect the intricate structure of ICC arbitration. The journey begins with the initiation phase. The claimant, the party initiating the arbitration, submits a request for arbitration to the ICC Secretariat. This document outlines the nature of the dispute, the parties involved, and the relief sought. To initiate the process, a filing fee must be paid, which helps cover administrative costs. Next, we move on to the formation of the tribunal. The parties in the dispute have the option to select their arbitrators. However, in cases where they can't reach an agreement, the ICC may step in and appoint arbitrators on their behalf. In most instances, a three-member panel is the standard configuration for the tribunal. This panel typically consists of a presiding arbitrator and two co-arbitrators. However, parties may opt for a sole arbitrator if they agree to do so. Continuing on, we enter the case management phase. During this phase, a procedural timetable is established, mapping out key milestones and deadlines for the arbitration process. A crucial part of case management is the case management conference. Here, the parties, along with the tribunal, come together to discuss procedural matters, set hearing dates, and ensure the proceedings are well organized and efficient. Now, let's focus on the pivotal stages, the hearing and the award. Oral hearings provide a platform for parties to present their arguments, evidence, and witnesses. These hearings allow for a thorough examination of the case and ensure that all parties have an opportunity to be heard. Once the hearing phase is complete, the tribunal issues a final award. However, this award is not final until it has undergone rigorous scrutiny by the ICC court. This additional layer of oversight ensures the integrity and fairness of the arbitration process. Let's shed light on some of the key features that make ICC arbitration stand out. ICC arbitration prides itself on staying current with the evolving landscape of international disputes. The rules governing ICC arbitration are updated periodically to ensure they remain relevant and effective. The latest update, the 2021 ICC Arbitration Rules, reflects the organization's commitment to modernizing the process. One distinctive feature of ICC arbitration is its emergency arbitrator provisions. These provisions enable parties to seek urgent interim measures, even before the full tribunal is constituted. This ensures that essential issues can be addressed promptly, enhancing the efficiency of the process.
Now, let's explore AAA arbitration, often considered the American standard. AAA arbitration is administered by the American Arbitration Association, AAA, a not-for-profit organization dedicated to providing dispute resolution services, including arbitration.
primarily within the United States. Let's take a closer look at the structure of AAA arbitration. The arbitration process begins with the filing and initiation phase. A party initiating the arbitration, known as the claimant, files a demand for arbitration. This document outlines the nature of the dispute and the specific relief sought. To initiate the process, a filing fee is required, which helps cover administrative costs. Next, we move on to the selection of the arbitration panel. The AAA maintains a roster of experienced arbitrators. Parties involved in the dispute can choose their arbitrators from this list, ensuring a fair and impartial selection process. Parties have the flexibility to decide whether they prefer a sole arbitrator or a three-member panel to hear their case. As the arbitration process unfolds, certain procedural steps come into play. Parties engage in the exchange of information and evidence, a crucial step in building their respective cases. Moving forward, we reach the resolution phase. Oral hearings may take place, offering parties an opportunity to present their arguments and evidence directly to the arbitrator. Ultimately, the arbitrator issues a final award, which is legally binding and enforceable. AAA arbitration boasts several key features that distinguish it. One notable feature is its provision of specialized panels. Depending on the nature of the dispute, AAA offers panels with expertise in specific areas, such as construction or employment disputes. AAA is also known for its fast-track procedures, particularly beneficial for smaller claims. These procedures are designed to expedite the resolution process efficiently. That concludes our exploration of AAA arbitration, the American standard in dispute resolution. Each arbitration scheme has its unique characteristics, making it essential to select the right one for your specific case.
Now, let's unravel LCIA arbitration, a preferred option for disputes involving European entities. LCIA arbitration, facilitated by the London Court of International Arbitration, LCIA holds a distinguished position as one of the world's oldest arbitration institutions. It's often the go-to choice when it comes to resolving disputes involving European entities. Let's delve into the intricacies of LCIA arbitration structure. The arbitration process kicks off with the commencement phase. In this phase, the claimant initiates proceedings by submitting a request for arbitration to the LCIA Secretariat. This formal document outlines the nature of the dispute, the parties involved, and the relief sought. A registration fee is applicable during this initial phase, which contributes to the administrative costs of the arbitration. Next, we move on to the appointment of the tribunal. If the parties involved cannot agree on arbitrators, the LCIA court steps in to appoint them. For substantial disputes, a customary choice is a three-member panel. Proceeding into the heart of the arbitration, we encounter the conduct of proceedings. During this phase, a procedural timetable is established, ensuring that the arbitration progresses efficiently. Procedural rules are set to govern the proceedings. Parties engage in document production, exchanging essential materials. Witness statements may also be introduced, strengthening the respective positions. As we near the resolution, let's talk about the award. In most cases, a reasoned award is issued by the tribunal, providing a detailed explanation of the decision-making process. This award carries the weight of finality and is legally binding. LCIA arbitration possesses distinct features that set it apart. Known for its cost-effectiveness and procedural flexibility, LCIA arbitration offers an efficient and streamlined process. A noteworthy feature of LCIA rules is their allowance for the consolidation of multiple proceedings. This proves invaluable when dealing with related disputes, as it ensures efficiency and consistency. That concludes our exploration of LCIA arbitration, the European choice for resolving disputes. Remember, choosing the right arbitration scheme can significantly impact the outcome of your case.
Now, let's venture into the realm of ad hoc arbitration, a method that allows parties to tailor the arbitration process to their unique needs. Ad hoc arbitration is a distinctive form of dispute resolution. In this approach, arbitration is not administered by any institution. Instead, the parties involved have the liberty to craft a customized process, often guided by established guidelines such as the UNCITRAL arbitration rules. Let's delve into the structure of ad hoc arbitration. The journey commences with the commencement phase. Here, the claimant sends a notice of arbitration to the respondent, officially initiating the arbitration process. Importantly, no filing fee is required unless the parties mutually agree otherwise. Next, we navigate the process of selecting the arbitration tribunal. Parties are granted the freedom to handpick their arbitrators. This selection process ensures that the arbitrators chosen have the requisite expertise and impartiality for the case. Additionally, the number of arbitrators is agreed upon by the parties, granting them flexibility in determining the size of the tribunal. As we move forward, we encounter the establishment of the procedural framework. Parties involved reach a consensus on procedural rules. These rules often draw from established guidelines, such as the UNCITRAL arbitration rules. Additionally, they work together to set a timetable and decide on hearing dates. As we near the conclusion of the arbitration process, let's discuss the award. After thorough deliberation, the arbitrators issue an award. This award is typically final and binding, ensuring the resolution of the dispute. Ad hoc arbitration boasts key features that set it apart. One of its defining features is the maximum flexibility it offers. Parties have the freedom to tailor the entire arbitration process to suit their specific needs, making it highly adaptable. Ad hoc arbitration proves particularly valuable in situations where institutional arbitration may not be suitable, such as in culturally sensitive matters. It allows parties to design procedures that respect and accommodate unique cultural considerations.
Now for detailed understanding these different types of arbitration and have clear understanding of the schemas, please visit the site mentioned below in the description. You will not regret it. A comprehensive guide to understanding contractual world of FIDIC. To stay updated on knowledge-driven content, like, subscribe, and hit that notification bell. Thanks for joining us on the Growth Mindset Company channel. Stay curious, and we'll be back with more enlightening content soon.